Ever since the start of the pandemic, the government has issued numerous regulations with the aim of protecting the health and safety of employees. This includes the limitation of maximum number of employees to physically visit the office or work to reduce the risk of spreading COVID-19 amongst employees, as well as the implementation of health protocols at the office. For example, mask wearing, physical distancing, self-screening, and vaccination. The government has also issued regulations and circular letters aiming to protect employees' salary and the sustainability of companies. This includes the Ministry of Manpower circular letter, which provide protection towards the employee's salary when the employees could not attend work due to COVID-19. Both confirmed cases and suspected cases in quarantine, provided that there is a valid medical certificate, and allows the employer and employees to agree on a salary adjustment and payroll schedule in order to ensure the continuity of the employer or company. The government also emphasized that termination or redundancy must be the last effort after exhausting any other available efforts, such as decreasing in operational costs, implementing work from home, and so on. The government has also granted subsidy for salary of employees who satisfy the requirements. Yes, it is possible for employees to work from home during the pandemic. In fact, depending on the ongoing situation with the pandemic, the number of employees to physically attend work at the office would be limited, and thus, some employees would have to work from home. This limitation is governed by each regional government and would change depending on the severity of the pandemic, and restriction should loosen when the situation improves. The implementation of the work from home system, determining which employees are working from home, for what period, whether it is based on company discretion or voluntarily, and so on, depends on each company. Each company may determine their own policy of handling employee requests, provided that it would not violate the prevailing laws, such as prohibition against discriminatory treatment of employees. Yes, in Indonesia, a termination of employment can only be carried out under certain grounds as specified under the law, and mostly must be legally settled by obtaining a final and binding court ruling on the matter, unless the termination is mutually agreed. An exception applies in cases where employees are terminated for urgent reasons, which allow employers to do an immediate termination subject to certain conditions. The example of permitted grounds for termination of employment are, among others, redundancy, force majeure, bankruptcy, acquisition, and so on.